Good evening, everyone. Welcome to UCL. I am Dr. Danai Azaria, Associate Professor of Law at the Faculty of Laws at UCL and co-convener of the lecture series of the British branch of the International Law Association, the ILA, that are hosted at UCL for the past 15 years. The ILA lecture series has been a long-lasting project at our faculty, and our vision has been to offer a forum for insightful discussions about significant topics of international law that include reach out to and engage our students, our academics, practitioners, and the wider public. Now, for those of you who attend regularly the ILA lectures at UCL, you will notice that tonight's lecture is an innovation. It is a joint lecture because the speakers have co-authored an excellent study on the subject that they will discuss, and the format of the lecture will be a bit conversational between them. I also have the privilege to chair tonight's lecture, and in this capacity, I would like to introduce our two esteemed speakers, and if I may add, also good friends, Professor Ingrid Brunk and Professor Monica Hakimi, or perhaps also Professor Monica Hakimi and Professor Ingrid Brunk. Now, Professor Brunk is the Helen Strong-Curry Chair in International Law at Vanderbilt Law School. Professor Hakimi is the William S. Beneke Professor of Law at Columbia Law School, and together they are the co-editors-in-chief of the American Journal of International Law. So welcome, Ingrid, and welcome, Monica. Now, their lecture tonight is entitled The Prohibition of Annexations in Modern International Law, and it is based on their forthcoming article in the American Journal of International Law. The accepted version of the manuscript is available on SSRN for those of you who desperately need to read it immediately, and I was obviously one of them. Now, having read the article, I can say that this is a piece of significant research in our discipline and one that will change some misunderstandings about the prohibition of annexation. Now, before I pass the floor to our speakers, I also want to mention that I have read this article to reflect also a deep concern that both authors have about the preservation of the prohibition of annexation in modern international law. And I also read you both as encouraging states to speak out and to defend the norm proactively, despite the political concerns that states may face in a new multipolar world that is full of uncertainties. Now, with these considerations in mind, and without further ado, I pass the floor to Professors Ingrid Brunk and Monica Hakimi.
Thank you so much. Thank you to the organizers of the lecture for giving us a platform, and thank you to the audience for joining us to discuss territorial annexations. We argue that the norm prohibiting territorial annexations is both foundational to modern international law and currently at serious risk of deterioration. So to start at the very beginning, by annexation, we mean the non-consensual taking by one state of the territory, either of another state or of a non-self-governing territory as recognized by the United Nations. We'll begin our lecture today by discussing a couple of current examples of annexations, which will be familiar to our audience, I expect. Then we will explain why the prohibition of annexations is so foundational to international law and what is at stake in its erosion.
Now, of course, that annexations violate international law is well known. But as we explain in our forthcoming article, and as we will discuss in more detail today, the international legal prohibition of annexations is, in our view, not well understood. It is often described as a corollary of the limitations on the use of force, the regulation of cross-border force, but it is also rooted in and itself brings together, we're going to argue, norms on self-determination and statehood. And seeing the prohibition in this more expansive way as tied not only to the norms on the use of force, but also to the norms on self-determination and statehood brings into sharper focus, in our view, what might be in stake in its erosion. It also shows that this prohibition has underappreciated historical roots in Latin America, in Asia, in Africa, and it allows us to clarify some of the modern doctrinal questions about it.
All right. And then after we place the prohibition of annexations in the legal context that Monica just described, we will briefly set out a set of geopolitical dynamics that we think threaten its erosion in multiple areas around the globe, Palestine, Israel, Ukraine, Western Sahara, South China Sea, and so on. And we are going to end on an optimistic note. We will conclude with a way forward, one that we argue can and should bring countries together across regional and global divides to ensure that territorial annexations and the violence that comes with them remain legally and practically out of bounds.
Okay, so a good place to start, since it no doubt will be on many people's minds, is the advisory opinion that the International Court of Justice issued this past July on Israel's conduct in the Occupied Palestinian Territory. And the court decided that Israel had acted unlawfully to annex Palestinian territory in the West Bank and East Jerusalem. And three aspects of the court's opinion are especially noteworthy for our purposes. The first is that the court explained that annexations in general are among the most serious violations of international law. Second, the court's logic suggests that the reason annexations are so serious is not just that they involve or might involve the use of force, they also unlawfully entrench the annexing state's authority in territory that does not belong to it, and they violate the self-determination of the inhabitants in ways that other uses of force do not or do not necessarily. And third, and related, the court cited as evidence of an annexation conduct that itself does not amount to the use of force, such as the issuance or non-issuance of land permits in the region and the building of a public transportation network. This third point is important because it highlights the distinction between annexations and uses of force, a distinction that we will return to. And it also shows that one need not look for a single massive event like Russia's 2022 invasion of Ukraine to see an annexation in effect. Even creeping annexations of the sort that Israel has attempted in the West Bank and East Jerusalem are, according to the court, unlawful.
So many scholars and commentators don't often see annexations as a distinct unit of analysis, one that cuts across geopolitical divides, and one that is distinct from other violations on limits in the use of force. So we're going to start with a couple of examples that sort of bring the topic together. So sticking to the Middle East, Israel also seized in its 1967 war with its neighbors a small strip of land in Syria known as the Golan Heights. More recently, in April 2016, Israeli Prime Minister Benjamin Netanyahu, for the first time, held a cabinet meeting in the Golan, and his purpose was, as he said, to send a clear message that the Golan will always remain in Israel's hands and is an integral part of the state of Israel. And then in 2019, the United States recognized Israel's sovereignty in the Golan. This, we argue, was in violation of the duty not to recognize territories that are forcibly annexed. So at the same time, Iran has evidently been acting through Hamas, Hezbollah, and other armed groups in the region to make good on its vows to eradicate Israel. This is part of the backdrop against which the horrific conflict across the Middle East, in Gaza, the West Bank, Lebanon, Iran, Syria, and Israel is now being waged. Second, and as well, we have Russia and Ukraine. Russia first acted to annex the Crimea region of Ukraine in 2014. At the time, it claimed that it intervened at the invitation of local officials. This is a fairly common pattern, and to further the self-determination of the Crimeans. There was a highly disputed referendum modeled specifically on Kosovo's 2008 Declaration of Independence. Most states rejected Russia's claim, but the attempted annexation of Crimea continued, involving low-level violence, and ultimately, of course, provided the basis to wage a broader conflict in Ukraine, including in 2022, Russia acted to annex all the territory of Ukraine in what has become a brutal conflict. One could also profitably ask where else Russia is sowing the seeds of annexation, including destabilization in Moldova. Third, Morocco. Here we also see some creeping steps toward annexation. It's been moving to finalize the annexation of the Western Sahara, a non-self-governing territory in North Africa. The ICJ's advisory opinion, as many of our listeners will know, reasoned that Morocco does not have sovereign title to this territory, but between 2019 and 2021, over 24 Arab and African states broke with the practice of not recognizing Morocco's title to Western Sahara and opened consulates to Morocco in the region. The implication of these actions was that the states would ultimately acquiesce in and might formally recognize Morocco's sovereign title. And then in December of 2020, the United States formally recognized Morocco's sovereignty over the entire Western Sahara territory, again, breaking with longstanding practice. And recently, France, too, has suggested that it would recognize Morocco's sovereignty over the Western Sahara. Fourth, China has increasingly militarized longstanding territorial disputes with a number of its neighbors, the South China Sea, the East China Sea, and in the Himalayan region. Ethiopia has entered into a deal with Somaliland, a breakaway region of Somalia, to give Ethiopia access to the sea and the right to establish a military base there. The terms of the deal have not been made public, but by some reports, Ethiopia offered to recognize Somaliland in exchange for those concessions. Many of these actions don't have the look of Russia's 2022 invasion of Ukraine, but each reflects an effort or a threat by one state to take the territory of another through coercion and without its consent. So these all creep toward annexations.
So now that we have like a sense of some of the annexations that are or might be happening in the world, we can speak a little bit more about situating the prohibition of territorial annexations in contemporary legal doctrine. And this prohibition is, as we mentioned earlier, often described as if it were fully subsumed within other international legal norms, and especially the prohibition of the use of force. So, for example, the ICJ itself has described the prohibition of annexations as to use its word, corollary of the prohibition of the use of force. But we argue in our piece that subsuming the prohibition of annexations into the prohibition of the use of force or into any other singular norm distorts both the history of how it evolved and its normative standing in contemporary international law. Because in fact, ending conquest through the prohibition of annexations has been central not just to that one set of norms on the regulation of the use of force, but to three central projects in international law. The first is basically a statehood project that involves the entrenchment of each state's authority in the territory assigned to it. The second is the regulation of the use of force across settled territorial borders. And the third is the self-determination of peoples within such borders. Now, as a historical matter, those who tie the prohibition entirely to limitations on the use of force suggest that it was fully realized through Article 2.4 of the UN Charter, which is, of course, the provision that contains the general prohibition of the use of force. But in fact, the prohibition of annexations was not fully crystallized as an absolute prohibition until around the time of the 1970 Declaration on Friendly Relations. And correcting its historical pedigree, as we do, by highlighting the significance of the Friendly Relations Declaration, brings to light the heavy influence of newly decolonized and non-aligned countries in its solidification as part of their agenda for their own self-determination, free from the external influence of more militarily powerful states. History prior to the adoption of the UN Charter also shows that annexations are part of the three projects in international law that we just mentioned. The old doctrine of conquest was limited during the 19th century, not by restrictions on the use of force, but instead by the rights of people located in territory that was annexed by the new sovereign. And even if the use of force was permissible, the argument went, the people who lived in that territory had a right to self-determination, so that sovereigns should not annex territory without some right or vote, a right of exit or vote by the people. So this early understanding of non-consensual annexations as violations of self-determination was the antecedent for the post-World War II efforts, including post-charter efforts, to prevent territorial changes as part of self-determination for newly decolonized states. And then separately, in early 19th century Latin America, we find diplomatic efforts to ban territorial annexations outright, in part as a way for newly decolonized countries, once again, to consolidate their control over their own territory as an aspect of their own statehood, a development that culminated in the influential Montevideo Convention, which again, unlike the Charter or the League of Nations and the Paris Peace Pact, specifically prohibited territorial annexations.
Turning from history to contemporary analysis, Article 2.4 on its face says nothing about sovereign title to territory. It regulates the use of force across territorial borders, and that is conduct that can overlap with, but is distinct from, an actual act of annexation. Now, compare that to the Friendly Relations Declaration that specifically says the territory of a state shall not be the object of acquisition by another state resulting from the threat or use of force. No territorial acquisition resulting from the threat or use of force shall be recognized as legal. Now, some commentators argue that Article 2.4 has the effect of prohibiting annexations because if a use of force is unlawful, then any territorial gain associated with that unlawful use of force is also unlawful. There are two problems from our perspective with this analysis. First, not all uses of force are unlawful. Self-defense, for example, is legally permitted. If annexations are unlawful because the use of force is unlawful, are annexations permitted in cases of self-defense? This question was left open by the UN Charter, and it was debated by scholars and within the ILC in the decades after the Charter's adoption. It remains a live issue. For example, we mentioned the Golan Heights. That's a place in which Netanyahu has specifically said that defensive annexations are permissible. It is the Friendly Relations Declaration, not the UN Charter, that resolves this issue and provides that all forcible territorial annexations are prohibited, whether pursuant to an lawful or an unlawful use of force. Second, if we subsume the prohibition of annexations into the prohibition on the use of force, we discount and we overlook its standalone significance. Consider many commentators' response to Russia's use of force in Ukraine. It was widely described as a violation of Article 2.4, which it was, but many commentators also failed to note that unlike other violations of Article 2.4, Russia is attempting to take Ukrainian territory for itself. Highlighting annexations as distinct from a use of force exposes the significance of this case for the norms on the entrenchment of state authority in defined territorial units and the self-determination of peoples.
And just to expand on that point, so the close relationship between annexations on the one hand and the entrenchment of state authority and self-determination on the other provide good reason not to subsume it, whether conceptually or doctrinally, entirely within the doctrines on the use of force. So the significance of territorial entrenchment as is independent from any regulation of the use of force is evident in a number of basic doctrines in international law. States collectively have provided that interstate borders, once settled, should be fixed without regard to any use of force. So as one prominent example, the 1969 Vienna Convention on the Law of Treaties permits states to invoke, and here's the language, a fundamental change of circumstances to terminate or withdraw from a treaty in limited conditions. But even in those limited conditions, states may not invoke a fundamental change of circumstances to terminate or withdraw from a treaty that establishes a boundary, is the language. The 1978 Vienna Convention on the Cessation of Treaties similarly protects treaties that establish interstate borders upon the breakup or dissolution of a state. So these treaties demonstrate that international law prioritizes territorial entrenchment, what we're calling territorial entrenchment, which is the entrenchment of each state's authority in the territorial boundaries assigned to it, even relative to other important objectives in international law. And the ICJ has repeatedly reinforced that position. So when states enter into a treaty that settles an interstate border, that settlement, the ICJ says, survives the life of the treaty. Here's a quote: "It is a principle of international law that a territorial regime established by treaty achieves a permanence which the treaty itself does not necessarily enjoy, and the continued existence of that regime is not dependent upon the continuing life of the treaty under which the regime is agreed." The ICJ's justification for this position is that any other approach, again, I'm quoting, would vitiate the fundamental principle of the stability of boundaries, the importance of which has been repeatedly emphasized. And indeed, much of the ICJ's case law over the years has focused specifically on clarifying states' territorial or, as a corollary, maritime borders, and thereby defining which state may exercise authority in which territorial or, again, maritime unit. The doctrine of uti possidendi is similarly defended by reference to the importance of territorial entrenchment. So the ICJ has described this doctrine as, again, quoting, among the most important legal principles in international law. Its essence, the court has explained, lies in its primary aim of securing respect for the territorial boundaries at the moment when independence is achieved. It is closely tied to the intangibility of frontiers and to the sovereignty and territorial integrity of every state, and provides for the, again, quoting, essential requirement of stability for states to survive, to develop, and gradually to consolidate their independence in all fields. Finally, the law of occupation works to entrench state authority over territory. It specifically distinguishes physical control over occupied territory, which may be lawful, from the transfer of sovereign title to that territory, which is unlawful. And because an occupying power does not itself have sovereign title, because it instead acts as the temporary trustee of the ousted sovereign, it must in general respect the laws in that state. It must provide basic protections for that state's population. It must not exploit the state's resources for its own gain. And it must do all of these things, even though it may still use force to preserve the peace in the space. So these rules, like the prohibition of annexations itself, help to ensure that each state's sovereign title remains entrenched and difficult to disrupt or change, even with a change in territorial control in the case of an occupation.
The prohibition on annexations is linked both to the prohibition on the use of force and, as Monica just described, to a set of norms geared toward territorial entrenchment of state power. As we've mentioned, the prohibition on annexations is also closely tied to the international legal norm on the right to self-determination. The ICJ has emphasized in a number of different ways the importance of territory to the right to self-determination of peoples who live in that space. For example, in its advisory opinion on the Chagos Archipelago, the court relied on the UN General Assembly Declaration 1514 to reason that the right to self-determination of the people concerned is defined by reference to the entirety of a non-self-governing territory. And the right to territorial integrity of a non-self-governing territory is a corollary of the right to self-determination. Similarly, the ICJ determined in its two advisory opinions on the occupied Palestinian territory that Israel's conduct there, including its conduct to annex Palestinian territory, violates the Palestinian right to self-determination. These cases and the facts that underlie them underscore that territorial entrenchment is integral to realizing the right to self-determination, consistent with the language of the Friendly Relations Declaration. These cases also indicate that coercively altering territorial borders, as annexations do, violates the right of self-determination of the people who live within them. In short, then, the prohibition of annexations is not the same thing as the prohibition on the use of force. It is its own standalone norm. And what makes it so significant in contemporary international law is that it ties together these really central projects of the enterprise: the entrenchment of state authority and defined territorial borders, the regulation of the use of force across national borders, and the self-determination of the people who live within them.
So, despite its centrality, we have good reason to believe, beyond the specific cases that we identified at the outset, that this prohibition, the prohibition of annexations, is increasingly at risk for three interrelated reasons. So first, there has been a growth and consolidation of competing security alliances since Russia's 2022 invasion of Ukraine. NATO is, for now at least, as strong as it has ever been, with Finland and Sweden having recently joined and more of its members ramping up their support. On top of that, the United States has fortified its security alliances in the Indo-Pacific with Japan, South Korea, Australia, New Zealand, the Philippines, India, and Vietnam, and in the Middle East with Israel and a number of Sunni Arab states. Meanwhile, the United States' staunchest adversaries, Russia, Iran, North Korea, and China, have been building and strengthening their own alliance, while each of these states flexes its nuclear capabilities at the same time. The trend to solidify antagonistic alliances would by itself be troubling, because as Paul Post has recently explained, and here he cites the work of William Langer, quoting Post, rapid movements toward alliance formation and consolidation often precede the outbreak of major wars, including World Wars I and II. Once such alliances are fortified, even local or regional conflicts, such as the ones in Ukraine and between Israel and Palestine, can more easily be internationalized, as has happened in both of those situations.
So the second development that we see as very troubling in this space is that even aside from outright annexations, territorial conflicts around the world have escalated recently. There are many examples, some of which we've mentioned, including tensions on the border of China and India, tensions between Ethiopia and Somalia, Guyana, Nagorno-Karabakh, Western Sahara, South China Sea, and others. Not all of these fall within our definition of annexations, but they are about assigning title to territory, and in some situations, the maritime zones that accompany territory. The data shows that interstate conflicts over territory, after declining in what some people call the long peace, has significantly risen even just since 2010. And extensive long-term research in history and political science shows that disputes over territory are more dangerous than other kinds of interstate disputes. Disputes that involve claims of historic ownership are especially difficult to resolve. These territorial disputes are more likely than disputes over trade or disputes over ideology to escalate into a militarized conflict. And even once militarized, these are the conflicts that are most likely to become large scale. So in our view, the prohibition of annexations is critical to preventing such conflicts. The prohibition, in effect, locks territorial allocations in place, making them harder to change. Conversely, an erosion of the prohibition increases the prospects of acquiring territory by force, and thus increases the incentives to renew old grievances over historic trends. This second trend, the increase in territorial conflicts around the world, is especially dangerous in light of the first one that Monica described, the rise in antagonistic security alliances. All four states that are often viewed as an alliance against the United States are flexing muscles to control territories that the United States is committed to protecting. So the United States and its allies have tried to isolate Russia following the attack on Ukraine, while other states in Russia's alliance, Iran, North Korea, and China, have actively or at least passively supported it. Indeed, there are recent reports that North Korean troops are on the ground in Ukraine fighting for Russia. So China's efforts in the South China Sea and elsewhere, those butt up against an alliance that is actively fortified against it. So the United States is positioning itself against China through its hardening alliance with Japan, the Philippines, Australia, New Zealand, and India. If this wasn't distressing enough, last year, North Korea signaled a shift in its policy toward the South. Obviously, South Korea is a U.S. security ally. That shift is away from reconciliation and toward confrontation. It opened up the possibility, and here using North Korea's words, of completely occupying, subjugating, reclaiming the Republic of Korea and annexing it as part of North Korean territory.
The third trend, on top of the other two, the hardening of security alliances, the increase in territorial conflicts, and of course the relationship between those two, is what appears to be a fairly rapid decline in effective US power. So as the United States is becoming, for a whole host of reasons, less willing and less able to assert global power in a way that it once did, Others are flexing their strength, including by taking or threatening to take territories that do not presently belong to them. And so even assuming that the United States has the political will to stand by its security commitments, it could not possibly make good on all of those commitments at the same time, as they are increasingly at the same time being put under threat by those on the other side. So more of these allies and partners are likely to face coercive attacks on their own territories, whether overt or indirect, and we should not take the sort of pronouncements to the effect of North Korea's as just empty talk and not indicating, not signaling some real intention or potential for further action.
Let me just add that one can observe that a decline in U.S. power might have this effect without taking a position on the situations in which the United States has used its power to good or to ill. So we don't actually mean to be taking a position on whether it's good that U.S. power is declining. We'd be happy to talk about that. But the point here is whether or not you think that is a good development, whether or not you think that's an overall net benefit for the world, it may well have this effect of emboldening countries who were restrained by U.S. security commitments, and that's really the only point here. But for our focus on territorial stability and annexations, it's an important point. All right, so to shift gears a little bit and turn to something of a conclusion, it's a good place to acknowledge that the norm against norm prohibiting territorial annexations comes with very significant trade-offs. It should be clear to every listener that the way that international law has allocated territory and state authority has contributed to the arbitrary separation of peoples and ecosystems. It may well have made internal ethnic conflict more likely. It may have made cross-border ethnic conflict more likely. It's provided the basis for shielding governments from human rights abuses within particular states. It's limited migration for people who are understandably and justifiably fleeing war, poverty, and environmental devastation. It's allowed states to shirk on measures to protect the environment and provide other global public goods. And it's systematically and at a very large scale reproduced past injustices for entire populations. So the world order that is protected by the prohibition on annexations is one that is deeply flawed, and it is deeply flawed in part because international law has helped construct it that way. Our argument is, at the moment, the world currently lacks any plausible alternatives to replace territorially defined states as the main units for political organization in the world. The erosion of the prohibition on annexations, and with it, the broader set of norms that protect states' territorial borders from forcible change, threatens to have negative and long-lasting consequences, perhaps most especially for poor and disenfranchised people. As the world is increasingly caught up in a contest about the future order, a critical question is whether new social and political forces can emerge and create a better world order without first taking us through a period in which territory is up for grabs through military force. If we're not able to do that, the horrors that we have witnessed in Ukraine and occupied Palestinian territory may well repeat themselves in many parts of the globe.
So let me just end by bringing this back to where we began with the July 2024 advisory opinion of the International Court of Justice. The ICJ, in our view, has put the world on notice, and we are trying to increase the salience of that notice with talks like this one. Solving the Israel-Palestinian situation is necessary, the court says, not just to stop, the court says, to stop the suffering there. And it is necessary, we say, not just to stop the suffering there, but also to forestall other human suffering. The world needs, as the court says, to ensure the right of the Palestinian people to self-determination, including its right to an independent and sovereign state living side by side in peace with the state of Israel within secure and recognized borders for both states. It must neither allow Israel to annex Palestinian territory, nor allow Israel to be annexed by the increasingly militant forces that seek completely to eliminate it. The failure to meet this challenge is often taken to be a purely geopolitical problem, and it clearly is, in part, a geopolitical problem, but it is also, we've argued, a significant legal problem. And putting it in legal context, we hope ties it together with the importance of denying Russia a territorial victory in Ukraine, the need to maintain the territorial integrity of and the self-determination of people in the occupied Palestinian territory, in Western Sahara, and with other measures to forestall other potential or attempted annexations, such as what's happening in the South China Sea. States should take the ICJ's warning seriously, in our view, and as an opportunity to come together and find a positive path forward, because however else they might jockey for power in the future world order, and they will indeed do that given the dynamics that are already in play, they should still at the same time do whatever is necessary to reinforce the prohibition of annexations in all of the settings in which it is now at risk, or the effects for humanity will be severe. Thank you so much for your time, and we look forward to your questions.
Thank you so much for this really insightful lecture, and I admit that it has flowed so smoothly between the two of you. So great new format. We might implement it more in the ILA lectures. So the Q&A is open, so people can start placing their questions. There are some questions already placed there. I will try to read as many as possible and ask. I will first perhaps exercise my privilege as the chair to ask the first question. I just wonder, both of you, what is your position on whether the rule is a jus cogens norm, but also, in connection to that, wouldn't that have an impact on how you assess whether it is under threat in terms of erosion? Because the nature of the norm will also have an impact on how resilient and resistant it is to change, and then the interpretation of the different reactions of other states to particular incidents.
I'm happy to lead off, Monica, or you can jump in. Yes, I can refer you to a post we wrote for EJL Talk on this exact topic. You can find it very easily, arguing that the prohibition of annexations should be understood as a jus cogens norm. What's interesting about your question, and one of the things that interests us about it, is there seems to be some confusion about this. If we went through a lot of the briefing for the advisory opinion, the ICJ's advisory opinion in July, and states made a variety of different statements about whether the prohibition of annexations was a jus cogens norm, or was some of them said it explicitly, others didn't say it at all. So there are certainly state parties out there who believe that it is a jus cogens norm. It is not on the standard ILC list of jus cogens norms, and we think that's a mistake. We think that it should be recognized as an independent jus cogens norm because we think it has the significance that we have that we have described. Of course, other norms with which it is closely related, such as self-determination and the prohibition on the use of force, do have jus cogens status, which we think just underscores the case for ensuring that it does as well.
And just to answer the second part of your question, Danae, to jump in, which is, well, as I took you to be asking, like, if it is a jus cogens norm, as we think it should be, does that in some way solidify it against efforts to detract from it? And I guess I would say, like, as a formal legal matter, yes, that it does. But we know that what counts as formal international law does not always reflect the on-the-ground practices. And we think that there is a serious risk here, as with other jus cogens norms, of sufficient practice that contravenes it, that even if it does not, formally speaking, detract the jus cogens status or the prohibition itself, nevertheless makes it lose its salience and results in people across the world being subjected to really forms of violence. And the other thing I will say in that regard is that most norms do not just sort of like rise and fall. So either it's like a use Kogan's norm or it falls, but norms that, you know, take shape and change and transformify over the course of their lives. And so, for example, one of the reasons it was such a big deal when it became clear that the United States was itself justifying acts of torture in violation of use Kogan's norm is that it was defining torture so narrowly, such that even if one still accepted that torture was itself a use Kogan's norm, the United States was creating sort of the normative seeds for defining the norm still use Kogan's and still formally binding in a more constrained and cramped way than it has historically been understood. So for example, just to bring the analogy home, if states were to start doing what Russia did in Crimea, which is to sort of create the facts on the ground for claims of self-determination within a breakaway region, and then say like, well, we're actually advancing the self-determination element of this use Kogan's norm by getting the Crimeans to say that they self-determined by being associated with Russia, that could have an effect on the understanding of the norm as a formal legal matter. And even if it doesn't, it would have an effect on the effect of the norm as a practical matter. So I take your point about like the use Kogan status helping to solidify it, but I also just want to underscore it's not enough to solidify it. What we also need is sort of the kind of social and political movement that Ingrid mentioned at the very end of our talk.
Yeah, but I mean, doesn't it also need a little bit of more clear legal claims being made by those that... So in other words, has anyone suggested any of those that are trying to annex, have they suggested that the annexation itself is lawful? And so, because that's when perhaps a claim for modification of the law is happening, and that's perhaps when states should be expected to be reacting quite forcefully, I would say. You're right in that sense.
You know, one of the things that we mentioned that's happened in the conflict, Russia's invasion of Ukraine, is, you know, it is widely understood as a use Kogan's violation. And that's because it's a violation of the prohibition on the use of force. And a lot of the early commentary in particular, you know, highlighted this invasion as sort of the last step in a long series of violations of Article 2.4, many of them by the United States. And I think that's a very important narrative. It's a very important story to tell. I think it's important to link Russia's invasion of Ukraine back to what happened in Kosovo, and ask questions about the use of force in Kosovo and, you know, that violation of Article 2.4. But a lot of this conversation has drowned out the specific focus on territorial annexations. You know, there was a very poignant and moving statement by the Kenyan ambassador to the UN right after the invasion, you know, in which he really understood the invasion of Ukraine as a problem that had to do specifically with territory. He linked it back to Uti Posididis, an African decision not to revive historical claims to territory, to simply let those claims go. So, you know, we do think it hasn't, and, you know, we think that was an important statement. It's not how many people have chosen to see the conflict. And then the conflict quickly became a lot about geopolitics, and understandably so. But what is Iran's position? What is China's position? How does the conflict mirror or not mirror what's happening in Ukraine? We just want to push this additional lens forward, and we wish that more states were focused on it.
I will start taking some of the questions. Thank you so much. Obviously, your answers are really complete. So Marco Stankovic is asking, so if the prohibition of annexation is eroding, what is the most effective way to start rebuilding it? So to create that resilience, what would you suggest now? Because you are suggesting we should try to address this, but what's the best thing you think?
I think we should try to bring states together specifically around this norm, right? So again, if we take the Russian invasion of Ukraine, we have, many states who didn't join the sanctions regime, and I understand that, and they didn't join the sanctions regime partly because they view the conflict as a regional European conflict, partly because they view the conflict as a proxy conflict between the United States on the one hand and Russia and China on the other. If this is how you see the conflict, there's not necessarily a lot of reason to line up one way or the other. Just we think understanding territorial annexations in Russia as linked to Golan, as linked to the occupied Palestinian territories, as linked to Western Sahara, provides a core norm that a very large number of states should be committed to, even if they differ geopolitically on many other issues. I realize that's not really a task that lawyers ourselves here in the ILA lectures are in a great position, but to the extent we are, that's one way forward.
And I would just also add to that. So yes, and the ICJ has essentially invited the General Assembly to do exactly this in the context of the Israel-Palestine conflict. There you have a situation in which both sides understand themselves to be facing an existential threat to their existence as states and as political communities. And if the General Assembly took seriously its task in contributing to peace and security, it could very well be a forum, not just for trying to, squeeze one side or another, however much that might be justified on other grounds, but also to actually come up with a positive program for action for putting in place the structures and systems and norms that are necessary to achieve the end that the ICJ says is ultimately the goal. And so the General Assembly, which has, of course, asserted itself more strongly than it in the past, however many years than it had since like the 1970s, is really a locus for decision making here, and could very well step up to the plate.
Mm-hmm. There are so many questions, obviously, so I have to be very selective, and I hope everyone can understand I cannot take all 21 questions. So I can see there's one question that says that is asking about prohibition of annexation not flowing necessarily from Article 2, Paragraph 4 of the UN Charter, but from the Friendly Relations Resolution, or being confirmed there. Is there any significance, Gal Cohen is asking, to the fact that the paragraphs in that resolution discussing prohibition of annexation are under the title of the principle of non-use of force? So what are your views on this? And perhaps take one more question, if that's okay, and we can kind of answer both. Goodness. So there was one question earlier. My goodness, the list is so long. About pre-1970s practice, and whether you see different practice perhaps in pre-1970s as opposed to post-1970s in relation to the prohibition of annexation, and why you think that might be the case.
Okay, why don't I answer the first question and you take the second one, Ingrid? Okay, so on the question of the significance of placing the prohibition of annexations not under the title use of force, we think that is significant. It's not dispositive. I mean, our argument is that it is tied to all three of these norms, including the prohibition on the use of force. And so we don't want to understate the significance of the prohibition of annexations, of that relationship between the prohibition of annexations and the regulation of the use of force, the prohibition of the use of force more generally. But we do think it's relevant that the General Assembly Declaration, the Friendly Relations Declaration, treats it as distinct from the prohibition of the use of force and ties territorial integrity, which the prohibition of annexations helps to secure, to the self-determination of the peoples living there, and not just to, or not even particularly to, the prohibition on the use of force. Ingrid?
Yeah, I want to just return to that and emphasize the symbiotic nature of this relationship. So if Article 2.4 is successful in prohibiting uses of force, except within the narrow allowed confines, then almost very many examples of territorial annexations go away, right? And we don't want to overlook this relationship, right? If you can't use force, if your use of force is very limited, your ability to use force to take someone's territory is also limited. So a world in which Article 2.4 is fully effective still leaves open some questions of territorial annexations, as we have highlighted, but a large group of them go away. So there is that relationship. There's also the relationship if you can no longer get territory as a legal matter from the use of force, then you're less likely to use force. So they are integrally related. And if Article 2.4 of the UN Charter has been successful in limiting the uses of force, we acknowledge and agree that that would bring down the uses of force for territorial acquisition. And now this gets to the data question, which is a really interesting one that I'm not going to do justice to, but I would refer you to the paper because we do refer to some of the best data that we could find out there on this. And as many people know, interstate conflict, dropped on most measures. There's a lot of different ways to measure it. There's noise in the data, but the way most people analyze it, interstate conflicts did drop dramatically after the charter was put in place. The question about whether territorial annexations dropped in relation to the Friendly Relations Declaration, which I think is the question that got us started here, is one we worked to tease out. We did not wind up putting much weight on that data in the paper. The number is small, but there is the data does suggest that there actually was a drop sometime in the 1970s, 1980s in territorial annexations. One of the things that we do know that happened is for a long time, the annexations that were attempted became associated with what people call low value, what the political scientists, not the lawyers, call low value territory. So attempted annexations persisted, but they tended to be in places where the annexing country didn't think that anybody was going to notice because it was trying to annex a piece of desert in which people didn't live, and that sort of thing. So I haven't really done the data justice, but whoever asked that question, we agree. It's a fascinating one, and it's a really good one. We don't rely a ton on that drop in the paper, but the data is there.
And if I can just add one footnote to that, which is one of the things we explain in the paper is that a couple trends, what came together at the time of the Friendly Relations Declaration is, on the one hand, a really assertive push by newly decolonized and non-aligned countries to solidify the prohibition of annexations as an absolute norm, associated with, again, territorial entrenchment and self-determination and principles on the use of force, which of course are also contained in the Friendly Relations Declaration. So that push on the one hand, and on the other hand, the solidification of a lot of the security architecture that is now beginning to erode, and that is a practical matter, helped to provide for territorial annexations not to occur at sufficient pace, at a very rapid pace. So it's noteworthy that for all of the other United States's uses of force and violations, the one thing it really did not do since 1948 is try to annex foreign territory. And some will say, well, it didn't need to, it was able to assert its power in other ways and so on. And that might very well be true. We're not, again, defending the way in which the United States has exercised its power. We both see real problems with it, but it's just significant that for a long period of time, the most militarily powerful states, including the hyperpower, did not engage in this particular violation, and thus allowed the norm to stand, even as it actively worked to loosen other norms with which it is related.
So do you think that is an interesting Very interesting point, and I think it is quite a strong point. But I wanted to ask you: do you think with the rise of regional hegemons, let's put it this way, especially in a more multipolar world, then is it more likely than that the prohibition of annexation would be undermined rather than having one hegemon? But if we now start having regional hegemons, would that change? What would you predict? And I suppose the data that you have in the paper might suggest towards a particular direction.
It's a question with a lot of dimensions. I think, some of the most recent geopolitical data I've read is skeptical that we're really reaching a multipolar, that, what we have is a sort of bipolar, and a lot of states kind of positioning themselves in between those two, which is different from a truly multipolar order. But I'm just going to go with optimism and hope that whatever multipolar order we might come up with, it would be effective. I mean, these are, really geopolitical considerations, not fully legal ones. And to some extent, I would say your answer is as good as ours. I mean, I think that the hard part here is a lot of people want to see the world order rewritten. And there's a lot of great reasons to sort of rewrite and revisit the entire global order. The one we have is not fair, and it's done a lot of damage. And anything that stabilizes that order, in one sense, is probably going to help keep their prohibition in place, and things that destabilize it probably don't keep it in place. We'd like to decouple those developments a little bit, and allow states to really think about some core norms of international law that they'd like to stick with, even as they are destabilizing other things. And we happen to think that territorially defined states is a pretty good place to start in terms of what we would like to keep. But we know many people will disagree about that. That wasn't exactly an answer.
It was a good answer. I wanted to take one question that by Sanitia Kalika. I will paraphrase, because I think that the question that that is being asked actually is even bigger. So I wondered what your view is about the prohibition of annexation and the passage of time more generally. So does it matter how long you have annexed a territory, for how long? Does it matter for the law?
We spent a lot of time thinking about this question, and I think as a practical matter, it does matter. And then the question is, at what point what is the point in time where you say, like, okay, anything after this is no longer permissible? And there are different ways of answering it. You could say at the point the norm was finally solidified. You can say that at the point statehood was, for all intents and purposes, established. So those are not completely overlapping points. So the data points or moments in time. But I think the question is really profound, because it gets at the point that Ingrid has now mentioned a couple times, which is the prohibition of annexations comes with real trade-offs, and real trade-offs for the people who lost out on a deal at some point in time. And not just for them, but especially for them, and especially if they are continuing to hold on to sort of like historical conceptions of their sense of belonging in the world, which many peoples do, and tie that to land, which many of course do. So the sort of trade-off is to recognize that at a certain point, we're going to stop fighting about territory, and we're going to find other ways to provide for human beings, so that they can, having been denied that part of their essence, they can nevertheless flourish and have emancipatory potential as communities and as human beings. That is ultimately like the choice that one needs to make. And as we end the paper, and as we ended the talk, like, not everyone will be on board with exactly that choice. It's just that we don't see good alternatives unless you are willing to tolerate very, very high levels of violence and dislocation for many of the same peoples who this norm is ultimately designed to protect.
Ingrid, are you, do you want to answer as well, or it's fine? Okay, and
Excellent.
before I close, I wanted to ask you, because I really enjoyed the paper, and I'm sure our audience will certainly enjoy it when they read it. Do you think that, having done now this research, and it is a really deep research, do you think there is space for more research in this field? Is this an area that you would recommend for people to start doing research, the issue of annexation?
Oh my gosh, we didn't even get close to exhausting it. I know in the U.S., and I'll just speak here historically, one of the things the paper does is center in the 19th century Latin America, the anti-war movement and decouple the idea of prohibiting annexations from just being an aspect of the anti-war movement. So some people view, again, this is linking it to the use of force. That's not the way it unfolded historically, as we said a little bit in our talk. So the broader project of sort of centering Latin America and also focusing on the interwar period as a very important period for norm stabilization. There is a lot of work to be done for those who are interested in history in the interwar period. And I would also say in the period immediately following the enactment of the UN Charter. And, the paper has some interesting stuff in it also that about the Kuwait, that when Iraq invaded Kuwait, and what brought countries together really to push back against this annexation. So that's just the history side. And now there's many others too. I'll let Monica finish the.
Well, just to add, so absolutely on the history, but then also, one of the things we try to do in this paper is to say, like, we need to approach a number of problems together and through a lens that is different from the use of force. So in light of some of this research, like if you make the prohibition of annexations central to or foundational to the bedrock of contemporary international law, you might see things that you otherwise overlook. You might see them in new light. So for example, regime change is something about which international lawyers are appropriately allergic, and they try to squeeze it into the prohibition on the use of force as much as possible. And that makes sense. But if you use annexation as the core, and you say it's all three of these projects simultaneously and not just one, you could say, like, actually, one of the reasons regime change is so problematic is not just that it might or might not really involve significant uses of cross-border force, but it also, of course, it allows a foreign entity to entrench its authority in a certain way in the tentacles of the host state and undermines the self-determination of the people who live there. And that might be a better register for understanding what the problem is than simply shoving it into Article 2.4. So you might, if you use this as an analytic lens, you might sort of see things in all sorts of different lights, and you might actually come to think, as I have admittedly come to think, that statehood is a very fragile thing that is worth preserving in the absence of alternatives. That doesn't mean it's worth preserving in exactly its current form. Actually, to the contrary, like, lots of states need to reconstitute themselves and rebuild themselves and are struggling. But that the state as an entity, which has long been a project of international law, has sort of been taken for granted, I think, for a long period of time. And one of the things that I think really requires further attention is, like, on what terms is international law actually going to support states, and by whom, and what kinds of states is it going to help support and create?
Thank you very much. Oh, sorry, Ingrid.
Yeah, no, I just wanted to add, I also think related to, I'm sorry, there's just some really interesting work in political science on territory itself and territory as an aspect of statehood. And I think those are very fruitful additional areas. And now I'll let you conclude this lecture. Thank you.
Thank you very much, everyone. Obviously, this lecture, we could have continued for hours. And also, it is really on a very optimistic note to say that there is space for further research and with different lenses on. So with that, I thank you very much, Monica and Ingrid, for this lecture. And thank you, everyone, for the really great questions. And, well, we will see each other again.
Thank you so much for having us and for discussing the topic with us.
Thank you for the great questions and the wonderful platform.
Thank you, everyone. Good evening.